Unlike Madhavi, I think I can profess to be objective because I haven't appeared as a counsel in this case. And in spite of Professor Bakshi reminding me that I don't like the basic structure theory, I proceed on the assumption that the basic structure theory is the law of the land. And my criticism will be within the confines of the basic structure theory. Now, my first objection to the majority judgment is on a point of principle based on democratic accountability. This judgment concentrates on one aspect of the basic structure, that is independence of the judiciary, and ignores other equally important aspects of the basic structure, such as the democratic form of governance and a system of checks and balances. Now, if our courts, if our superior courts have the power of judicial review, they have it because the people, through the Constitution, have given the courts this power. And therefore, the people, through the legislature and through the executive, must have a participatory role in the appointments to the superior judiciary. I look at it from another point of view, the point of view of a very humble service lawyer, which I am. You have an appointing authority and you have a removing authority. The removing authority of the judges is Parliament. It defies logic to say that the removing authority can have no say at all in the appointments process. So this is my first objection on principle. Second, while we must accept the theory of basic structure as being part of the law of the land, it is difficult to accept derivatives of the basic structure as this judgment purports to put forth. Yes, there can be no quarrel with the proposition that independence of the judiciary is part of the basic structure of the Constitution. But it is difficult to accept that primacy of the judiciary in the appointment process is also part of the basic structure. So this is derived basic structure. Let us assume, for the sake of argument, that primacy is also a part of the basic structure. But primacy in what way? The NJSC amendment and the Act gave effect to primacy by giving institutional primacy to the judiciary. The point which Madhavi made, I'm putting it in a slightly different form. If in a 6-member body, the judiciary is in a 3-member majority as compared to 2 and 1 in my view, institutional primacy has been has been accorded to the judiciary, but we want to stretch it by saying this won't do. It has to be overwhelming primacy. That I find difficult to accept. The judgments, the majority judgments, proceed on a deep distrust of the executive. On a deep distrust of the executive, which comes out unwittingly in an observation in Justice Lokur's judgment. He says, the present political executive is unlikely to agree to the appointment of a gay candidate. Now, one of my colleagues reminded me that it was the judiciary which upheld the constitutionality of Section 377. Therefore, if the political executive, the law minister, says, I object to this person because he or she is gay, they are only giving effect to the law laid down by you, the judiciary, because the law minister would rightly object to a person who has criminal propensities. I don't think, with great respect to Justice Lokur, he thought through this point before making this observation in his judgment. Next, the judgment is based on the completely short-sighted assumption that independence of the judiciary is to be secured only against the political executive. No, an independent judiciary means not just a judiciary which is independent of the executive, but a judiciary which is fair and impartial, which means judges must be free from the influence of corporate houses. They should be free of members of the bar, of leading law firms. They should be free and independent of their families, of the career interests of their families. Now, like all other professions in our country, the legal profession is also hereditary and dynastic. Both judges and lawyers who accept outsiders can interrogate judges on these aspects and examine these aspects also before finalizing an appointment. And it is a fallacy to think that judges alone are competent to decide on the suitability of judges. This fallacy which has come from Justice Verma's time in the second judge's case, that the courts are the arena of performance of lawyers, and then who other than the judges are the ones who are suitable, who are fit to judge the competence of those to be appointed to the bench. Now, judges can only assess the technical competence of lawyers, which means their learning, their erudition, their skill in marshalling arguments. Judges are not and have not shown a capacity to interrogate their colleagues on their beliefs, on their social philosophies. We wouldn't have got this 377 judgment if there had been a system in place where judges had been interrogated on their social philosophies before being placed on the bench of the highest court. And therefore, it is essential to have outside elements as part of the appointment process. Secondly, whether you call it judges appointing judges or judges having an overwhelming say, judges are more concerned with giving each other a chance to make it to the superior court. They follow the rule of seniority subject to rejection of unfit. And so, judges come to the Supreme Court for 3 years. They are sworn in the day prior to their retirements. They accommodate each other without any sense of manpower planning, without having regard to the efficiency of the institution. Judges, look at the number of Chief Justices of India we have had who have had tenures of 17 days, 3 months, 4 months, 6 months. Has there been a single Chief Justice who has said, no, I will go on leave, let the next puisne judge become the Chief Justice in the interest of the institution, because in 2 months I won't be able to give any shape or direction? It doesn't happen because judges are as careeristic as you and I are, and therefore, for the sake of manpower planning also, you need outside intervention. I hope I have another 5 minutes, a contradiction. On the one hand, the majority says the present collegium system itself gives a participatory role to the executive. But then what is wrong with a 1/6 voting role to the law minister? This veto part, Madhavi rightly pointed out that the veto rule is embodied in the Act and not in the Constitution amendment. And so, if the judges had to strike down something, it had to be the Act, not the Constitution amendment. But I will go a step further and justify the veto rule. One doesn't have to feel shy about it. Now, a 2-member veto can operate in different kinds of situations. And remember, the third judge's case itself had recognized a 2-member veto. When the collegium was expanded from 3 to 5 by the third judge's case, Justice Bharucha, in his judgment, indicated that even if 2 judges have reservations, the appointment should not go through. Therefore, 2 judges vetoing in a body of 5 is fine, but 2 vetoing in a body of 6 is not good, because those 2 could be non-judges. Justice Chalmeshwar, in his dissenting judgment, rightly stresses the incestuous nature both of the judiciary itself and in a given situation between the judiciary and even the executive. So you can have 2 civil society members on one side in this veto context, or you can have 1 civil society member and a judge, or you can have 1 civil society member and the law minister. Now, so these are myriad situations where a veto can operate. And this veto, let's take a case where two laymen, the civil society members, exercise the veto. The situation which the majority thought was such an inconceivable, such an unacceptable situation. Now, the law minister can be a diabolical politician. Professor Bakshi gave one name. Equally, the law minister, and very often it has happened, that the law minister is an eminent lawyer who is going back to the Supreme Court to practice after his government goes out of power. Can we not visualize a situation where judges acting as a club are supported by the law minister who doesn't want to antagonize them because he is going to practice before them after another 6 months? What other safeguard can you have except this two-member veto? These are the points of criticism which I wanted to offer. Thank you so much.
Professor Bakshi, would you like to briefly respond to some of the comments that have been made? Or?
I would like very briefly to ask my colleagues in the panel to consider the question that worries the judges and the justices in this particular matter. Namely, 124 gave powers to the president. And if you, poor president, you know what figures in our discussion here. So there was, is the president bound by the advice of the Council of Ministers in appointing judges? Or is the president to act independently? That's one question. So the bill at least made the president subservient. Any decision of the NJSC was binding on the president. And that's where the law minister assumes a very central role, because law minister is a part of the cabinet. And you have to think a little widely. The second thing, Professor says so, is just going on the points that have been made, or things that are worried. As far as I know, neither the amendment, as you know, the Act, change the qualifications of citizens becoming judges. So all this civil society talk is diversionary, in our opinion. Because all the best that civil society can do, if a collegium were to exist, is to prevent some people, some names, from going to the president. They cannot appoint from their own. So it is the law now. By the Constitution, you have to be a lawyer of 10 years, whatever, what's the article I forget now. You can. So this is the idea that civil society, it will somehow broaden the scope of appointing judges, is a myth. Because you are not touched. The idea that appointing authority must not be different from dismissing authority is just who is the appointing authority? Is the executive or the president of India? And therefore I am very confused by this. There are other things, but I'll leave it later.
Okay, on the second first, is not my microphone. on the second aspect first, on the qualifications and eligibility criteria. In fact, Justice Lokur, in his judgment, one of the concluding remarks is that the NJSC, the whole thing is an empty package in a wrapping paper in the form of the NJSC and a ribbon in the form of the constitutional amendment, because there was no procedure laid out, no regulations. Now, this was the point, that should the government have laid out the procedure in advance, or should it have given the prerogative to the NJSC itself? Now, for the NJSC, the Act contemplates that it is the NJSC who will lay down its own procedure, its regulations, etc. And in order to do that, the NJSC needed to be constituted. For that, you needed, first of all, the selection of the eminent persons. And for that, you had to have the Chief Justice sitting with the Prime Minister and the Leader of the Opposition. So the point is that it was a chicken and egg situation. The NJSC never got constituted, and therefore the procedure never came. And in fact, Mr. Salve at one stage, he was appearing for one of the states in the early stages of the matter, and he said, he said that you are testing this much too early. You've got to allow it to work for a bit. You've got to allow it to be constituted, for the procedure to go through, and then to be tested, rather than just nip it in the bud. So I think the eligibility and all of that would have come, it just never got a chance to take off. As far as the president is concerned, very quickly, the judgment holds that the president was to act on the aid and advice of the Council of Ministers, and therefore he wasn't acting on his own. His position has been held to have been diluted by Justice Lokur's judgment. Although he is eventually the appointing authority, the recommendations have to go to him, and he doesn't have the power to refuse more than once. But the executive representative is therefore then the law minister, who is perhaps being, in charge of the law ministry. He may be in a better position to provide his input on the candidate. So that is the way it works.
As far as the position of the president is concerned, I don't think the position of the president is an aspect of independence of the judiciary, which is what is part of the basic structure. An amendment can dilute the position of the president without affecting the basic structure at all, because here we are concerned with the independence of the judiciary. I would also like to respond to what Professor Bakshi said about the role of civil society. What can civil society do? Now, in the present system, it is unlikely that an environmental lawyer, a feminist lawyer, a human rights lawyer, or a labor law practitioner who appears for trade unions, it is unlikely that such a candidate will come within knocking distance of the judiciary, because judges will say, look at her income level, or that he or she is so strident in her arguments, the courts don't like her, she is not fair, or that this gentleman, this passionate trade union lawyer, is a Ladaku, so it is unlikely that a 3-judge collegium is ever going to give such committed lawyers a chance. It is only if you bring in civil society, that we can bring in such elements in the judiciary which will contribute
to a more diverse judiciary.
Professor Bakshi, if I may just start with a question for you. In terms of just the reactions that you're seeing to the judgment, and if you may compare it to what you saw when the first judge's decision came and the second judge's decision came, and then you wrote in Courage, Craft and Contention that that this whole idea of judicial independence is a myth, and it is somehow lawyers trying to prevent judges from being accountable to people when you were writing in response to the first judge's case. I was wondering if the current context of in which the judiciary is operating, let's say now, there seems to be much more faith in or criticism coming of the court and faith in the political executive and parliament. Is it a weakening of the judiciary from what it was and used to be in the 70s and the early 80s, given its own track record on human rights issues and rights of the marginalized, and a sort of simultaneous strengthening of the political executive and parliament?
Several questions here. I look at one. Oh my God!
Yeah.
I look at my book. Look at a long time ago, but I do remember in the very first chapter in the Constitutional Craft Convention, I say you're right. But I do say that it's only relative independence. It's independence within dependence. Because for salaries, for age, for retirement, for a number of other things, judges' independence of judiciary is not affected if the executive has the upper hand. So it's a mighty authority in many ways there. That's the point. So it is executive laden judiciary. It is independent from the polity and the market. So in a sense, it is only independence is relative autonomy. There is no absolute autonomy. On the question of, on the second aspect of your question, is there a decline of faith? I'm not an empirical social scientist, so I cannot simply say. But I would like to think that, and as my guesstimate, that there is more faith, comparatively, popular faith in the judiciary, despite its darker moments. So you can't look over the dark moment. The Gage judgment was a dark moment. In fact, the Gage judgment, I don't know what the lawyers are doing. I'm not a lawyer, I just produce them. I'm quite helpless in this matter. The Supreme Court should be told has given a wrong judgment, because in the Gage judgment, it was first filed in the Supreme Court, and the Supreme Court relegated to the High Court, and relegated with the instruction that it should consider all aspects of the matter. That's why judgment is so long in the Delhi High Court judgment. Supreme Court had divested itself of jurisdiction. It had only one role, namely of accepting the judgment. But nobody, no lawyer in review the accused or substance or merits of the case, whatever I do, I'm not the Supreme Court has no role, because it farmed out APIL to the High Court, asking it to do all aspects of the matter. This is what it did. What role does the Supreme Court have? Now that question is not friendly, because lawyers also like to respect judges. They don't press beyond a point. The problem is about being very serious. The lawyers, their bread and butter, cream and cake, is on judges also. It's a very sensitive system, somebody said it's right. It begins, the bar is dependent on judges, the bar is independent of judges, both. When the judges are independent, they're dependent. So it's a nice word. People, of course, they come in civil society, they just put a phrase, which is very nice, with rules of mouth. the unwashed, unkempt people who are raped, whose houses are burned. That is civil society. Yeah, not civil society. Civil society are the people who were declared weaker sections of society in 1950 Constitution. Today it's what, 2015, 16, 13. They are still weaker sections. So I always tell my class that what the Constitution means, going back to original and subsequent, Constitution means by weaker sections of society, it means progressively weakened sections of society. Now, there is no way in which this progressively weakened section of society will have a role in playing power, because they are excluded by domination, and domination will continue. So there is no question. This whole therefore independent judiciary is a debate. I don't agree with this particular judgment in personally in my observation. So I think within what is available, independence of judiciary is available. We can still move them around with more concern than legislature can. That's my belief.
But Ms. Diwan, if I may just ask your view on whether you think appointments are an integral part of independence of judiciary, and you have instances like in the United States, Justice Hugo Black, who was a member of the Ku Klux Klan, goes on to become this absolutist free speech protector, or Felix Frankfurter, who starts being a liberal champion but goes on to become an extremely conservative judge. In that context, and do you believe that the procedure for appointments is part of the independence of judiciary, and is that further complicated by the fact that we now suddenly seem to have this extremely worrying practice of judges being given political posts, being appointed post-retirement. So in those two contexts, would you see independence, appointments as part of the independence of judiciary? Yeah.
Actually, this was one of the arguments on behalf of the union, that appointments is only one facet. The method of appointments is only one facet of the independence of the judiciary. And in fact, what is very interesting is the Constituent Assembly debates don't say such a great deal about appointments per se. But what they do say, and they spend a whole tedious amount of time on discussing salaries, allowances, tenure, all of that, post retirement benefits, etc. So they spend a lot of time in discussing these tedious nitty-gritties, and that was one of the basic methods of achieving a judicial independence, by ensuring that the tenure was secure, and that the judge would, once he was appointed, that was when the real, he would act independently, because in the knowledge that his tenure, his salary, his emoluments, all of that is very secure. So that was the major part of securing independence. As far as appointments goes, it's only one facet. And as in fact, Justice Chelmeshwar, in his judgment, he lists a whole lot of judges who had very strong political inclinations. Justice Krishna Iyer was actually, a cabinet minister, and there are a whole lot of them whom he lists over there, to say that, look, these people all made independent, wonderful judges, once you're a judge. And yes, you're right about, I think, post-retirement is a problem, because it's so imminent. It's so imminent because, when you're on the verge of your retirement, you're in that position to appoint, to take decisions, and then, the other aspect, in fact, if I may respond at this juncture to this whole point on civil society, what can civil society do? Well, one of the two members are required to be from, either SC, ST, or minority or women. And I think that, you know, one of the questions you ask about the gay judgment, I think, as Raju rightly said, it would have gotten, you know, somebody would have interviewed a judge and asked him his social outlook and general social awareness, etc. Because I did attend some part of the hearing in that case, and you know, we were amazed to find that one of the judges was candid enough to say that, you know, I have never met a gay person in my life. So it's not as if, you know, he didn't seem to know that, look, gay people don't wear placards saying, you know, hey, I'm gay. So you know, this is the thing. So we need to know a lot more, and he may have been, you know, an outstanding judge in every other way, his knowledge of law, his conduct of his court, all of that, but, you know, somewhere in the process, the social outlook. The other thing is, as far as, you know, social diversity, women, for example, the fact that you have in the lower judiciary, we seem to have a lot of women because they, you know, the pure merit in the sense, you know, they take an exam, they clear it, and they're there. But as you go higher, it just diminishes to the extent that in the Supreme Court you have one woman out of, you know, and in fact last year when the Kenyan Chief Justice visited our Supreme Court, and his first response was that, you know, there's only one woman in the Supreme Court, and that is really outrageous. And incidentally, their Deputy Chief Justice is a woman, and a woman of Indian origin. So, you know, that is the kind of social diversity, and that's true of a lot of African countries. And India is way, way behind. So I think, you know, somewhere this civil society has an eminent persons who will ensure, one, on social outlook, and two, to ensure that there is diversity within the judiciary.